Okay, welcome everyone. This is our ongoing podcast series, and we're very happy to have Ian Hull here of Hull and Hull law firm, and they specialize in estate planning, estate litigation, everything around the estate. And thanks, Ian, for joining us. Ian and I go back to our high school days at North Toronto Collegiate Institute, and we moved on from there to Western, where we actually were in the same fraternity, Sigma Chi. So we've known each other for many years and have followed each other's careers since. And Ian's been very supportive with our business over the years. We used to call him a board member, but the OSC doesn't like that title anymore. So now he's just been someone who gives us some guidance from time to time. So welcome, Ian, and Joe, Ken, and I will hopefully be able to walk us through somewhat of an entertaining discussion about everything around the estate. Maybe do you want to just introduce yourself and let the audience know a little bit about yourself?
Sure. Thanks, Dave. Real privilege to be here with everyone, and I look forward to our discussion. I've been working in this area for over 30 years. Started with working in as a lawyer in a general commercial litigation practice, and then joined my dad in 1992 and created the firm of Hull and Hull. We do estate, trust, and capacity litigation work and estate planning work. So we've got the whole spectrum of sort of pre and post-death organizing your affairs work. A lot of my personal work is in the contentious area, so I've got a good perspective from that standpoint on what I'd like to do prior to the problems arising and avoiding these kinds of problems. So that's sort of my specialty, and we've got 20 lawyers, so we've got lots of help around us to battle through some of these tough issues.
Yeah, getting to know your practice over the years. One thing I remember you told me how you've really got your business. Like, where does your business come from typically?
Basically, it comes from lawyers and advisors. That's the main sort of source of my work. I've got sort of on the street a bit of a reputation as being someone who does estate work, so I get those kind of referrals that way.
And maybe you'll just put your thinking cap on, come up with some stories about some of the cases that maybe you're able to talk about. Obviously, protect the names, or don't mention names to protect the innocent. But there's been some interesting ones you've told me, so we'll come back to that later. But why don't we just start off with some simple discussion, really, on when someone's really starting to update their estate plan and their wills and things like that. How should they prepare for that? What's the best way to get oneself organized? And just a little bit more preamble here. It's usually the last thing someone wants to do. No one wants to think about dying and that. But how do you get someone motivated to get themselves more organized to do these things?
Well, you're so right about the motivation. It is very tough to get people to focus on this. I'm literally just redoing my will, and I hadn't done it for 20 years, and here I am in the business. So I'm the worst offender. I think what I like to tell people who sort of are trying to get either their affairs rebooted or started is to ask around and get comfortable with your choice of a lawyer. That's a very important thing. You need to go, you want to work with someone that either has a system or has the expertise or the connection with you to make the process even less friction in the process. The starting point that you can expect a lawyer is going to ask about is typically we will send out a checklist of a document that is either we do it all online, but a document that allows us to get as much information as we can about your affairs before you come to see us. And that's a point of friction sometimes in terms of getting things moving with the state administrations and with this will planning. But I always look at it a little differently, and I'm sort of, as I say, refreshed into it just having redoing mine now. It was a good opportunity for me to sit down and really look at my affairs. With your group is so good at sort of annual or semi-annual connections with your clients to talk about the financial affairs that you're working with them on. Sometimes a complete regroup of all of your financial affairs, looking at everything from that perspective. And we'll talk later about the assistance that advisors can bring to the process. That is a really important step as well, because sometimes it allows you to sort of rethink the direction you may be going or not going, or maybe an opportunity to think about going back to some of your advisors and asking questions. So the first thing you want to do is you're going to be expected to give some core information to us in advance if possible. If you give nothing, that's not a big deal. We can draw it out in a meeting, but I always recommend that people take the time, and it's usually, as I say, it's either online or it's on a document that you can send back to the lawyer. Take the time to go through that document very carefully, sort of after dinner or a couple nights or something, where you're just poking away at it and pulling out some of the data that you have and you're being asked to give. Little things matter, where you were born, residency, things like that, not just financial holdings. And so that's why I think people, they actually give themselves a bonus by taking the time to filling out the questionnaire.
Okay, now I wasn't aware that you're updating your will, so I want to make sure you know how to spell my last name properly. So let's go through it carefully here. And Joe's is really hard to spell, so
Yeah, I'll email you mine just to make sure it's clear.
good. So glad we got that straight. But no, I'm just trying to keep this lively here, and it's something that people don't typically want to do. How often should people be updating these once they do get a will in place?
Well, there's two sort of rules of thumb I think of. One is change in an event in your life that really matters. A marriage or a divorce or grandchildren is another opportunity to reconsider your will and so on. But and I didn't follow it myself, but 5 to 7 years, it's worth getting it looked at. I will talk about later maybe some changes in the law. A couple of recent changes and not so recent changes have dramatically affected estate planning. So it's worth revisiting this with your lawyer. And as I say, coming back to the point of just, it does give you a chance to sort of regroup and look at your overall circumstances and not just your wealth, but your plan and where you'd like your money to go. And maybe a charitable choice has changed or you hadn't thought of one, things like that.
Okay. Back when I started into this business, I worked for a trust company, and one of our roles was to get the trust company named as a corporate executor, corporate trustee. And part of my role was to get as many as I could through people. And I must admit, probably a mistake I've made in my career was naming the trust company in some cases where they didn't need to be named. Just go through like who should be named as the executor and trustee for a typical estate, and then when should you bring in a corporate executor?
Well, yeah, it's a good point about corporate executors. The choice of executor is such a personal choice. I don't, it's funny, I don't think of the choice of executor being driven by anything other than someone who is organized, can make good business, sound business decisions. That no one has to be sort of, have at the same level as you guys in terms of financial administration and things like that. But they need to have someone that you can trust to make sound business decisions. And then, of course, the most important is someone you can trust because they're going to face a whole series of events and circumstances that are just simply not predictable. You just do not know precisely how things are going to unfold. And so that's the starting point. Lots of people ask me, well, if I have kids, should each of the kids be the trustee? Well, again, it's a personal circumstance choice. If your kids are in the US, it's not a good idea to have them as trustees. It creates all sorts of problems. If your children are across Canada, it used to be a bigger problem. Now it's not as much of a problem because the technology has caught up with administering estates. So if your one child lived in Vancouver and you lived in Toronto, it used to be a real pain in the neck to administer an estate. Now it's a lot easier. But you need to think about the family feelings and the hard feelings that might arise if you picked one over another. Those sorts of things are important. But, all in all, if we sit back, and the choice of executor is in my view, the most important step. So it needs to be thoughtfully done.
Joe, would you want to jump in with any preliminary questions?
Yeah, I do. And last week I was out in Mississauga speaking to a group of physicians. And of course, you might know we have a lot of existing investors that are physicians. And one of the things that, I think the financial side of the community recommends is that married physicians each have their own medical professional corp. Have there been issues kind of from a legal estate perspective that have created problems in regards to this, like one physician in a marriage dissolution saying, I'm entitled to a cut of this corp because I contributed to it. So that's one question.
Yeah, the planning, it's the same in the legal profession now. We are allowed to do professional corporations. The planning with professional corporations can get a bit complex, but we in our office, we do encourage multiple wills. Obviously, you're right about giving advice to having the two docs, if they're married, having their own professional corporations. We actually, as lawyers, have to have a lawyer as our executor for our professional corporation. So we can't just appoint anyone. So for example, I'm doing my planning. I'm doing 4 wills because of that, and that because of that, the planning problems that can arise. So yes, it's a really good idea. And again, coming back to the choice of your lawyer, good lawyers can do these documents in a pretty efficient way. We use software, and we have a product called the Estate Planner that we use, and that's a software program that we use, and it can efficiently produce the wills in a way that can allow for the crossovers of these corporate entities and the planning that comes out of it, because the planning for you at the corporate level is different than the planning for you at the personal level.
Right. Yeah, I got a secondary, and thanks for that. I got a secondary question that, originated from a discussion I had this weekend. And it's a sensitive subject, but the reality is medically assisted dying, as I understand it, is legal in Canada under certain circumstances. In your experience, have there been any issues on the estate litigation side that have originated from a situation that began as a medically assisted dying situation?
Yeah, we do run into it a lot more. As you say, MAID is medically assisted dying is a very precisely organized process, and it is very surprisingly limited how much we can use it. I think we all should be working with our government representatives to encourage them to expand it in a way, because we're kind of halfway there now with medically assisted dying, and it's a bit it can be a bit difficult, but the insurance community came out early and said that if you use medically assisted dying, it doesn't affect your policies. The planning side of things, there are lots of cases which we're running into where if someone's going to challenge the validity of a will and they died from medically assisted dying, is that someone who had the sufficient cognition because they were able to engage medically assisted dying? Is that sufficient to engage making a change in your will? So those circumstances have arisen, but there are literally hundreds of people that are engaging in it now, and so I think probably over the next 5 years we're going to see more and more of it intermingling into contentious estates.
And then just the last one, how do our investors, let's say like they haven't gone down this path, because in our industry you have to be registered to practice or to manage money on a discretionary basis. Are there sort of specialized credentials that lawyers in this area that our clients should look for if they're looking for somebody in this area?
Yeah, Joe, that's a really great question, because in law, we don't necessarily, if you do criminal law, you can still do a will, and, it's not necessarily a good thing. So it's worth coming to guys like yourselves, getting advice on who is the right person to assist with the will. And sometimes you go to someone who's not qualified and you don't get the fulsome advice. Where the legal profession is struggling big time, of course, is online wills are very prevalent now. And, the need to differentiate it, which I think is obvious just because I know this area so well, but the need to differentiate between an online will and a will done by a lawyer is dramatic. And the point is, if you go to the right lawyer, you're going to get the right advice, and you can find that you might not be getting the fulsome advice that you need when you go to a lawyer who hasn't got at least some expertise in it. And I also talk about to my clients and say location's important. Obviously, location where your lawyer is. So if someone in North Bay wants to do a will, they're not going to use our firm. That's the reality. But I want to make sure that I've helped them, engage them with someone who I have confidence with.
Yeah, yeah, and I'm sure you're connected. So if someone did ask us in British Columbia, then you could either do
Oh
it
yeah.
online with them or have someone to meet from your past. Let's talk about family dynamics. Every family is different. Every family comes to the table with their own unique set of circumstances. Typically, you see estates, divided equally amongst the surviving children. after all the spouses are both spouses are gone. That's a very typical situation. Maybe show us some other examples of what you've had to contend with and how you've either planned in advance with the family to protect them for things or how you've had to do things after the fact.
Sure. Well, the family dynamics drives everything, as you say, Dave, and you're right. Everyone's got their own shtick and everyone's got their own tensions within the family. But sometimes what we describe in our business is what look for red flags. When you ever, and hopefully no one in this podcast ever has to, but if you get in a situation where you have to challenge a will or you're trying to attack an estate plan after death, the courts always want to know what was the rationale. What was the and you know that and that analysis is what drives most of the decision making. So I always think of that and I think, okay, let's work backwards. What is the rationale? Well, the family dynamics draw on the rationale so deeply. Obviously, certainly in our firm, husband and wife come in, young kids, it's to each other and to the kids if they both pass away. That kind of planning is rote and it's important, certainly when you're in your young age, when you have young kids, but that kind of planning starts to unfold in a way that it gets more complicated. So easy illustrations to look for is obviously siblings, children that are living outside Canada. Brings in a whole different layer of estate administration issues, but it also can bring in a whole different layer of tension because that child may not just be as active in terms of day to day with their parents. And obviously, that could bring about either a rational change to the will or some resentment on death. The other sort of low hanging fruit is children that aren't around. And then the other low hanging fruit is children involved or not involved in the business. Those, no matter what, those are red flags that you need to, as a lawyer, I need to address with my client and make sure that we've considered what they are and what we can do to accommodate that obvious tension. Now, lots of my clients say, "Oh no, the kids all get along. It's great." Well, the glue unfolds very quickly when one of the parents dies and certainly when both the parents die. And so the tensions that were sort of kept under the rug for many years tend to float to the top and not always result in litigation, but you want to have as smooth of a state administration as possible, and that tension could be brought up by the fact that the one child that doesn't live in Canada is angry because the other child got to become executor. It's a little thing like that, and they feel that there was something that's been building for many years, and that child was always treated unequally. Fair and equal. Fair is not always equal, and equal is not always fair, because from my standpoint, anyway, you're as all of you guys see it every day too. You're in your business. The family tensions can be addressed. They can be worked through. We go through sometimes very elaborate processes by having family meetings and organizing things in a really professional way to bring out some of the issues. But when we know that there's an issue there, it seems to me that one of the great added values of the advisor community is to address those tensions. And all you have to do is be in the business a few years and you can start to identify where they're going to come from.
That's great. So every situation's unique. Powers of attorney. Explain what they're used for, and I think you need more than one. Maybe just go through some of and those are really important while people are still alive.
Yeah. So in Ontario, and it's across Canada, there is some of the same flexibility, but Ontario for sure, the way it works is this. You're entitled to, under the Substitute Decisions Act, create two powers of attorney. One is a power of attorney appointing someone or a trust company to look after your financial affairs. So that's a power of attorney for property. And then there's a power of attorney for personal care. And that is a power of attorney. It's a separate document where you're giving someone the authority to address personal care issues. And it can be as simple as making sure that you're cared for in the home properly, or the parameters of a power of attorney for personal care are fairly obvious. The doctors at the hospital will often want to know who the power of attorney for personal care is to allow them to assist them in making medical decisions. the crossover is important, and the choice of who you pick is crucial. If you're going to create attention, an easy, obvious area of attention is that when you have combating, if the two siblings don't get along and you've named one as power of attorney for property and one for personal care, you're probably walking yourself into almost an obvious situation of tension and maybe fighting. The one thing that powers of attorney for personal care don't have is authority over the assets. So an easy illustration is if you have two competing siblings, children, and the one child says, listen, I want to put my mom into the most expensive place in town, and I don't care what it costs. And the power of attorney for property says, well, listen, I want to do as much as we can for mom, but guess what? There's not enough money to do that. So we're not going to do that. We're going to put her in here. And then there's creating the tension. So choice of who it is for property and personal care is vital. And it's so vital because, of course, let's be honest, you're alive. The choice of executor, albeit important, you're not around for it, for the fallout. So I always say to my clients, make sure that we create wills and powers of attorney. And again, those need to be updated in the same cadence as wills do, given the changes in the law and the changes in legislation.
Good. How do you best organize your team of advisors when you're starting the estate planning process?
Well, what I always say to my clients is that, the will making process, although has obviously the negative connotations that we talked about earlier, the will making process allows you to bring in and to assess the team that you have, both on the financial advisor level, the accounting level, and on the legal. Now, there may be more expansive advisor groups, but those are the sort of three core groups. And it gives you an opportunity to either reintroduce or introduce your accountant to your financial advisor, and you may get some great uptick from that, from having just done that. You bring in a lawyer, of course, and if you have an opportunity to create primary and secondary wills, you've avoided tax on an asset with the snap of a finger. And so what I try to do is I always have in my questionnaire, who is your accountant and who is your financial advisor, so that it allows me, and I ask them if I can liaise with them. For example, it's important to check in with your group for designations of beneficiaries. If we're not going to do it through the will, I want to know if it's been done through your shop and does it accord with the estate planning. I had a client the other day come in and their assets are relatively large, but they're very upset, very cognizant of being equal. And so they came in and said, listen, I want to give the RSPs to the other child because I just gave the one other child some money to buy a cottage. And I said, okay, great. Well, we can either do it through the will or we can call your advisor and work with your advisor to regroup that. And it was easy because I already had the advisor information, and I'd already had 2 contacts with the advisor anyway when we were doing the estate planning. So it's really important to keep some sort of synergy between the 3 core group of advisors.
Okay. One new thing that we've been filling in on our annual client reviews with our clients is towards the end of the updated Know Your Client form. There's 3 boxes that we check. I don't have them in front of me right now, but a new box that we check and encourage people to agree to is that once they pass away, we still are able to manage their money. Maybe to talk about some of the drawbacks there with the way the system is right now, where someone dies and that means all investment decisions are frozen. Maybe just take people through what happens there.
Yeah, it's a really important question because there's a lot of variations on the theme, but you've got sort of 2 pockets of effort that we do, and that is 1, create the plan, and 2, administer the plan. And for example, post death access to funds is vital. The minute you advise the bank that someone's passed away, they freeze the account. All right. So that's and it is a universal step. It's not one that I've always totally embraced, but that's the reality. So if you're going to have that situation, I'll often have tough discussions with the client saying, look, let's not just talk about what your assets are and who they're going to in an equal way. Let's talk about what do the first 6 months of your administration look like? What do the first 18 months of your administration look like? And those are 2 very important things because access to funds is crucial in the first 6 months. You're going to have to pay ongoing. I mean, not all the expenses don't just stop. So we'll often say make sure the TFSA or something, one of your assets is available for early distribution. If they have life insurance, that helps a lot. But even that, if it's going through a corporation, it can get delayed in terms of its distribution. It's and then of course your deemed disposition tax. So everybody in Canada pays a tax on the value of the increased value of your asset on death, and CRA wants that paid in 18 months. It's becoming more and more of an issue to administer estates with that in mind. So of course the classic situation is if you've got a family cottage and there's a big tax built into that on the capital gains side. On death, it's payable within 18 months. Well, how are we going to fund that? We have in Ontario, the court system is really tied up. Obviously, if you're going to litigate, you can be into matters that can take years. But an administration of an estate, until recently, the estate office in Toronto was giving out probates within 6 months from date of death. So you're looking at a period of time between zero date of death and 6 months where you have access to no funds. Now, the banks will sometimes pay for expenses as you go along. Like, for example, if there were sort of automatic withdrawals to keep the house heat, hydro, and water on and things like that. So I'm not saying that it's completely in chaos when someone dies. There is some room for flexibility, but it's case by case, it's branch by branch, and it's bank by bank. Nobody can write a guidebook on how to administer through the banks, because the truth is that there's no real pecking order in terms of who's making the decisions, and it almost never goes up to legal. It almost always stays at the manager level, and so some managers can be more flexible than others. So all of that said, looking forward, within the first 2 years after date of death on how the money is going to flow is important. So it comes back to your point, Dave, like, for sure. I mean, first of all, you're not going to need access to all of the money immediately. And so not just frozen, but do you want it to be just sitting in a GIC? Say you guys liquidated it and sent it out to the executor. Well, there may be no economic value to that. So there's all sorts of opportunities to be flexible on the timing of the administration. There are some rules that prevent assets being distributed before certain periods of time in terms of the tax filings, but generally speaking, you want to give as much flexibility to your advisors and the lawyers within the first 2 years of date of death financially.
Okay, that's helpful. I'm sure you get asked this question all the time. What are some successful ways to lower probate fees and or avoid them?
Well, unfortunately, the tax system is such that there are very limited options, but probate fees are one that is, with a good lawyer, something that can be managed very effectively, and it's in a material amount. I mean, you can manage your probate fees far in excess of whatever a lawyer would cost to do a will. Just on managing, or for example, you could manage, if you had a joint account with your child, you could establish a secondary will that puts that account into the secondary will and therefore avoids the probate fees. And if it's an account with $1 million in it, probate fees 1.25%, 1.25% tax on it, you save yourself $10,000 before, and you've just, that's literally by creating one document. The idea of creating probate fees avoiding probate fees is really driven by a secondary estate planning tools. As I say, I've got 4 wills I'm doing now because I have professional corporations. So I've got my primary and secondary wills in my personal world and my primary and secondary wills in my corporate world, because some assets you cannot avoid probate. So for example, if you own an asset that is held by you personally and it's in an investment portfolio, most of the time the banks are not going to release that investment portfolio without probate. Having said that, there are ways to plan around that, as I've described, a joint account or putting corporations into secondary wills and things like that. So and this comes back to where we started, Dave, in the sense that initial questionnaire, the detail matters because we can give advice on the nature of that asset that will literally, as I say, without breaking a nail, pay for way more than what you pay for your lawyer to do the documentation on just one asset. And the probate avoidance is the easiest one.
Okay, that's helpful. Yeah. So our clients will hopefully reach out to us with questions about that because no one wants to pay more than their fair share in tax. One topic we talked about before, and uh, I think this might be interesting. Any sort of notable recent changes in the law?
Sure. Just a couple of little things. I mean, the probate primary and secondary will planning is not that recent, but still people don't know it's there. So that's very important. That was a big change in the law. And the other is the Ontario government has changed it, made will drafting a little bit more flexible. It used to be that if you didn't have a will perfectly signed, so the person in the room with two witnesses there, that will could not be valid. And it was a very hard and fast rule. Um, it's still a good rule. It's still the primary test that you want to certify the validity of a will is that it was attested to with two witnesses at the same time. But the government just recently changed it to allow some flexibility. So if there is a tiny screw up on that, there's a way to comply with the law and to save the will, so to speak. But what's happening is, it's as anything, the legislation came in a couple of years ago and things are being tested by the courts. And what's happening is that the courts is getting almost too flexible, and they're allowing documents that you wouldn't have thought were a will to become wills. So my advice to my clients now is more and more is to just stay away from writing notes and just making a sort of I want to make sure that this vase goes to my daughter, those kinds of notes. The courts are so flexible right now about what a will is that you might be careful what you've done in terms of the planning. So stay focused with an advisor and a lawyer to get it documented properly, because the pendulum has gone the other way, and it was for good reason, but it's a bit nerve-wracking. Now I said when someone dies, we have to do an incredibly extensive search for any document that might look like a will, and that's not what it's not good for your planning, and it disrupts all of the efforts that you've done. And an easy example is if you do a will and you've avoided your probate tax and it's all tickety-boo, and then you go and write a note that changes something, that could undermine your whole structure, and you're going to be paying the probate tax. So just be careful to don't use self-help with will drawing and estate planning. It can get very dangerous.
Where should someone keep their will once they've, or wills plural, once they've finalized them? Does that matter based on their age and stage in life, or what are some good rules of thumb there as to where should they reside?
Well, there's two things there. Some lawyers, our firm we don't insist, we offer to keep the will. So we have fireproof safes where we keep the wills. The original will is very important at the time of probate and the time of administration. So it's one of the last things that a wet signature in an original document really matters. And that may change. It's already changed out in British Columbia. There's now electronic wills in British Columbia, but we do not have that in Ontario. So the original will really matters in terms of the administration. And so where it's kept really matters, as I say. So some lawyers will keep it in their office. That trend has dropped a lot in the last 10 or 15 years, and most people are taking them with them. So if you're going to keep your wills and powers of attorney, there's two things in that regard. One, your wills, keep them somewhere safe. I mean, nobody has safe deposit boxes anymore, but the top drawer of your dresser may not be the right spot either. Obviously, if there's a fire or anything like that, it could get destroyed. The powers of attorney are very important to keep in terms of where they're kept and who knows where they are, because you need to be able to access them in a situation where you're not well. So again, some people will keep one copy of it with their lawyer, and they'll keep a few copies at the house. All of these documents are very important documents, and so they shouldn't be loosely sitting around. A, because you want to be able to preserve them, and B, they're very private documents. I can't tell you how much over the years I've seen cases where real tension within the family occurs because someone went, snooping around and found the will and couldn't believe what was going on. That if you want to keep your privacy, obviously that's crucial. So I often will tell my clients to, obviously, and that's a personal choice, but somewhere safe in the house is fine, but make sure that someone knows where your powers of attorney are at minimum. And remember, once you become the attorney for property, you actually have to go look at the will of the individual, because you need to know what the estate plan is. You're not bound by it, but if there's an antique car that in the driveway that's going to a nephew, you're supposed to try to, as long as there's enough money for other things, try to preserve that asset for that child, that nephew. So these documents shouldn't be loosely sitting around, nor should they be loosely considered. And so we, at our firm anyway, we offer to hang on to them.
Okay, that's great. We should probably wrap up maybe on one final topic. Maybe, Jeff, have any cross-border stories? As you know, we take care of clients across Canada, and now in the state of Florida, we've got an SEC registration down there. Any rules of thumb for families that have family members living in different jurisdictions around the world?
Yeah, I mean, it's great that you've got Florida because that's probably, from an Ontario perspective, the single most cross-border jurisdiction we deal with in our office in terms of volume. People just tend to go down to Florida from Ontario. A couple of small things, and again, this comes back to your personal circumstances. Choice of executor in Ontario can be more important if you've got U.S.-based assets, because that person is going to have to navigate things at a more sophisticated level. It's just simply it's not very, but it is complicated administering assets if you have a cross-border situation between, as I said, let's just use the Ontario-Florida situation. In Florida, you need to have your own Florida will if you have an asset there. It's very important to do that. And so I make sure my clients have identified someone they can use in Florida as the proper executor. It needs to be a local individual. So again, you're able to you have to create some sort of advisor relationship down in Florida or another jurisdiction. Any jurisdiction that you own assets in, you should very seriously be considering doing a will in that jurisdiction and powers of attorney. So that's the sort of mechanical first step. The other is, of course, looking at the tax options that you have available to you in the context of that. Canadian assets on death are universally are worldwide taxed. So there's only so much you can do, except depending on the jurisdiction you choose, you might have some flexibility there and some planning there. Really important to consider these because the local taxing arrangements can be draconian. I mean, Florida, just to pick on Florida again, you die with an asset in Florida that you haven't done any planning on, you could be facing a very serious level of tax in excess of 50%.